Are we on? I hereby call this meeting to order. This is the Code Enforcement Special Magistrate for the town of Highland Beach. Cases will be called in the order in which they appear on the agenda. When you hear your case called, the city will start and it will introduce the case and present testimony and evidence. You'll have the opportunity to review any evidence the city presents and to ask questions of the town's witnesses or any evidence the town presents, after which time you can present your own testimony on any evidence and I will make a decision. This is a quasi-judicial hearing, which means the formal rules of evidence do not apply here. However, all testimony is taken under oath under penalty of perjury. So if you are going to testify today, or you think might testify, or there's a possibility that you might testify, I'm going to ask that you rise and raise your right hand so that you can be sworn in.
By the authority vested in me as a notary of the state of Florida, do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
All right, I have the minutes from, I guess this is June 10th, and they are hereby deemed approved with the correction on the date. All right. First case.
All right, first case is CC 25-185, and the town is pulling this one as the property's in compliance.
All right, case 2, B.
CC 25-310, the town is pulling this case as the permit's been issued and the property's in compliance.
So far, so good. All right, case C.
This is case number CC 25-253. My name is Adam Osowski, Town of Highland Beach Code Compliance Officer, and I've been previously sworn in. The property address is 2727 South Ocean Boulevard, 1004. I inspected the building records on June 5th, 2025. The violations that remain as cited on today's agenda are 30-122B. Permit P22-0138 has expired. The permit was submitted originally on May 20th, 2022. It expired due to missing inspections and unpaid fees. The notice of violation was served by certified mail that was sent on June 5th, 2025. The green card was returned signed on June 13th, 2025. The respondent was given 14 days to come into compliance. The notice of hearing was served by posting on July 21st, 2025, and certified mail was sent on July 16th, 2025. Prior to today's hearing, I re-inspected the building records this afternoon, August 12th, 2025, and the violation has been corrected. I have submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation, and the town is waiving prosecution costs in this case.
When did the property come into compliance?
This afternoon. I got a phone call about a half hour before the hearing.
So it was not in compliance with the required compliance date in the notice of violation.
Correct.
Is anyone here on behalf of the respondent? Anything further from the town?
No, sir.
All right, in case CC 25253, I make the following findings of fact and law. I find notice is sufficient. I find the property having been in violation of code section 30-122, the expiration of a building permit. Respondent came into compliance, but after the required compliance date, no costs are assessed. All right, D.
This is case number CC 25-236. My name is Adam Osowski, and I've been previously sworn in. The respondent is Stephen Rowe. The property address is 2727 South Ocean Boulevard, 1004. I inspected the property on May 28th, 2025. The violation as cited on today's agenda is 30-122B. Permit BR 22-0021, apartment renovation has expired. The permit was originally submitted on April 8th, 2022, and it expired due to missing inspections and unpaid fees. A courtesy email was sent on May 28th, 2025, and was ignored. Therefore, the notice of violation was served by certified mail that was sent on May 30th, 2025. The green card was returned signed on June 6, 2025. The respondent was given 21 days to come into compliance. The notice of hearing was served by posting on July 16th, 2025, after certified mail was sent on July 11th, 2025. Prior to today's hearing, I re-inspected the building records this afternoon, August 12th, 2025, and the violations have been corrected. I have submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation. The town is asking to assess prosecution costs in the amount of $250 payable within 30 days.
Is anyone here on behalf of the respondent? So this too came into compliance after the required compliance date and the notice of violation?
Yes.
All right, in case CC 25236, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation, having been in violation of 30-122B, has since come into compliance, but after the required compliance date. For failure to, for an expired building permit and failure to renew it, the respondent shall pay costs in the amount of $250 payable within 30 days. All right, E.
All right, the town is pulling this case as the property is in compliance.
F.
Town's pulling this one as well as the property is in compliance.
This is the month of compliance, huh? That's good.
All
The
right,
goal.
all right before the hearing.
It's my reputation, I bet. G.
That's right.
All right. This is case number CC 24-480. I am Adam Osowski and I've been previously sworn in. The respondent is Diana Cantor Trust. The property address is 3212 South Ocean Boulevard, 405A. This case was originally heard at the special magistrate hearing on January 14th, 2025. The magistrate ruled the respondent had 14 days to come into compliance or a fine of $250 per day would be imposed. The magistrate also charged the respondent a $250 cost of prosecution, which was paid on May 1st, 2025. On June 27th, 2025, the respondent's attorney notified the town requesting this case be heard so they can request a fine reduction. The property was in violation for 128 days after the date set for compliance. As of today, the total fine is $32,000. The town agrees to a 75% reduction to $8,000. The town also requests this one-time courtesy be paid within 30 days or the fines revert to the full amount.
Is anyone here on behalf of the respondent? Can you come up to the podium, ma'am? Go ahead.
There is a submission that contains the backstory to why my client was unable to.
I read it.
So it contains some sensitive material, but the gist of it is that she's absolutely, she has some serious medical issues. And she's been hospitalized 4 or 5 times since October of last year. She had, this is her deceased mother's apartment, which she was renovating. Contractor, we charged her $10,000 for what is $120,000 renovation. I don't know what you feel like. But her husband filed for divorce. after a 20-year marriage. Her 5 dogs were taken. Her car was repossessed. She became unemployed. Had a series of tragedies, and she simply was overwhelmed and shut down. It wasn't until she failed to respond in the divorce proceeding in New Jersey that a guardian was appointed. And it wasn't clear that the guardian had control over assets for which Ms. Camper served as trustee until I believe it was February. So I was brought in about the beginning of May. I think it was April 23rd. And things proceeded, and we've been taking care of everything. It takes a little time to find a contract, we can find a great one. And we're here to simply request that in light of her incapacity, you make an accommodation and waive the entirety of the fine.
The town is, has represented that they're willing to reduce it to $8,000.
Correct.
Is that what you're asking me to do?
No, I'm asking for it to be waived in its entirety. She's lacked the capacity. She was unable to respond. She wasn't responding to her divorce proceeding. She was in the hospital for much of the time.
Counsel?
I don't know if staff has, I'd be willing to take it down to 4. We really don't waive in the entirety. I don't think we, but 4,000, I think that's being pretty generous. I understand what you're saying, ma'am.
It is not like she was ignoring the town or being insubordinate. She was ignoring the judge in New Jersey.
I'll move it down to $4,000. How much time do you need, ma'am?
Well, we can do that within 30 days.
All right, 4,030 days.
Thank you.
H.
This is case number CC 24-115. I am Adam Osowski and I've been previously sworn in. The respondent is Michael Hazel. The property address is 3912 South Ocean Boulevard, Unit 702. This case was originally heard at the Code Board hearing on July 9th, 2024. The board ruled the respondent had 30 days to come into compliance or a fine of $250 a day would be imposed. The board also charged the respondent a $250 cost of prosecution, which was paid on October 22nd, 2024. On May 16th, 2025, the respondent notified the town requesting this case be heard so the owner can request a fine reduction. The respondent was a no-show at the June 10th special magistrate hearing, but later that day requested another fine reduction hearing set for today. The property was in violation for 238 days after the date set for compliance. As of today, the total fine is $59,500. I have been in contact with Mr. Hazel's new contractor. The town agrees to reduce the fine by 90%, which totals $5,950. The town requests that this one-time courtesy be paid in full within 30 days, or the fine revert back to the full amount.
So are you here for this case? Come on up. Can you tell me your name, please?
Tyler Hoover.
And what's your position with the?
I am the
respondent?
new contractor that helped Mr. Hazel out with his contracting issues, let's say.
Does he know that you're here representing
He
him?
does, yeah, I just talked to him actually. He's a war vet, been blown up a few times, like his hearing is gone, he's got one leg. Contractor took advantage, split town, left everything kind of undone. And he doesn't know kind of, I don't want to say which way is up, but just not familiar with anything that was going on, and obviously got letters, had a friend try and help him out with that. The friend was not capable of even doing that either. Here we are today. I gotta call Tyler, I need your help, about a month of 2 months ago or whatever. So I came in, fixed all the problems, fire department, everyone came out, everything is all satisfied now. And he even just called me now, he's broke. So I'm here to do whatever I can for him to help him out.
The town has offered to reduce it 90% to $5,950.
Okay, is that, I mean, is that the best that we can do on that?
It's pretty I'll be
I mean,
be
it's pretty
honest.
fair.
I'm the objective third party here.
Understood.
It's a pretty good offer. I don't know if the town wants to revisit that, but in considering 238 days. Yeah. it's pretty good.
I'm very appreciative of you guys even doing what you're doing now, so I'm okay with that. We'll get you the payment within,
The city asked for 30 days. Do you need more time than that?
no,
All right.
I'll pay it if I have to.
All right, in CC 25115, I'm going to reduce the fine from 59,500 to $5,950 payable within 30 days.
Thank you.
I think that's it, right?
That's all I have.
All right, with no further business before us, we are adjourned.